So what are the aggravating factors in California criminal cases? California has a determinate sentencing law that spells out the punishment range for most crimes. The possible sentences in a California felony case are known as the lower term, middle term, and upper term. The judge selects your sentence based on aggravating and mitigating factors. In addition to influencing the judge in the selection of your sentence, some of the aggravating factors can be charged as sentencing enhancements that carry added repercussions. However, just like the underlying charges that you face, any sentencing enhancement must be proven beyond a reasonable doubt, or you cannot receive additional punishment. You can't be punished for a sentencing enhancement if you're not convicted of the underlying offense. Also, prior convictions can't be used as both sentence enhancements and aggravating factors. As you can tell already, this is an exceptionally complex area of the law. Aggravating factors in California criminal cases can be related either to the offense itself or to the defendant. These are the offense-related aggravating factors that can be applied to a California criminal case. The crime involved great violence, great bodily harm, threat of great bodily harm, or other acts disclosing a high degree of cruelty, viciousness, or callousness. The defendant was armed with or used a weapon at the time of the commission of the crime. The victim was particularly vulnerable. The defendant induced others to participate in the commission of the crime or occupied a position of leadership or dominance of other participants in its commission. The defendant induced a minor to commit or assist in the commission of the crime. The defendant threatened witnesses, unlawfully prevented or dissuaded witnesses from testifying, suborned perjury, or in any other way illegally interfered with the judicial process. The defendant was convicted of other crimes for which consecutive sentences could have been imposed, but for which concurrent sentences are being imposed. The manner in which the crime was carried out indicates planning, sophistication, or professionalism. The crime involved an attempted or actual taking or damage of great monetary value. The crime involved a large quantity of contraband. The defendant took advantage of a position of trust or confidence in order to commit the offense. Now, these are the factors related to the defendant themselves that can aggravate a California criminal offense. First, the defendant has engaged in violent conduct that indicates a serious danger to society. The defendant's prior convictions as an adult or sustained petitions in juvenile delinquency proceedings are numerous or of increasing seriousness. The defendant has served a prior prison term. The defendant was on probation or parole when the crime was committed. The defendant's prior performance on probation or parole was unsatisfactory. Just like the aggravating factors that influence the outcome of California criminal cases, mitigating factors are also divided into those related to the offense and those related to the defendant, but those we're going to address in a separate discussion. Aggravating and mitigating factors can have a tremendous impact on the sentence in a California criminal case, so it's up to your attorney to bring in as many mitigating factors as possible. So that way the judge is aware of the good things, the good factors, and minimize those aggravating factors. If you or someone you care about needs a lawyer, call us right now for a free consultation. Our toll-free number is 1-800-NO-CUFFS, as in, get those handcuffs off of me. 1-800-NO-CUFFS is 1-800-662-8337. Call 1-800-NO-CUFFS today or check us out online at nocuffs.com.